Welcome to Community Legal Education Association's Legal Information for Tenants in Manitoba video series. This video is about what happens when your rental unit needs repairs. This video was produced by Community Legal Education Association Manitoba, or CLEA, with funding provided by Justice Canada. CLEA is located in Winnipeg, Manitoba on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the traditional homeland of the Métis people. Our water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and continues to be done. Therefore, we dedicate ourselves to moving forward in the spirit of reconciliation. This video contains information about Manitoba laws and is only intended for Manitoba residents. This video contains general legal information only and not specific legal advice. For legal advice about your specific situation, speak to a lawyer. Everyone's living space needs maintenance and repair. Damage to property can result from day-to-day living, accidents, weather, or other things like fires or flooding. Living areas need to be checked on and cared for so that small problems don't lead to bigger problems over time. Landlords and tenants both have responsibilities and obligations when it comes to maintaining a rental unit. When we are talking about responsibility for repairs, we are talking about both arranging for the repair to be made and paying for it. The tenant has to tell the landlord when the property needs repairs, and the landlord has to fix problems they are responsible for. Working together often leads to better and faster results. Sometimes the legal responsibility for maintaining a unit is shared, like in the case of a bedbug infestation. The tenant has to tell the landlord about the infestation, the landlord has to arrange for treatment, and the tenant has to prepare their unit for treatment and complete the recommended actions to help prevent the bugs from coming back. These include specific methods of doing laundry and cleaning. If the tenant can't do these things themselves, they must let the landlord know they need help. Tenants are responsible for repairing damage that they or their guests have caused, unless it is just usual wear and tear that happens over time. For example, if a tenant breaks a ceramic stovetop by dropping a pan on it, it's their responsibility to fix the damage. This responsibility includes making the arrangements for the repair to be done as well as paying for it. But if a lock or a doorknob in a unit wears out over a very long period of time, it is considered normal wear and tear and would be the landlord's responsibility. This means the landlord would arrange for and pay for the repair. If a landlord is responsible for a repair, they can't charge it to the tenant or add it to their rent or take it out of their security deposit. Landlords are responsible for keeping the building, rental unit, and facilities in good shape and fit for people to live in. They have to comply with building codes and standards related to health, safety, maintenance, and the number of people allowed to live in the building. For example, landlords must install and keep smoke alarms in rental units in good working condition. The landlord is responsible for fixing things like leaking pipes or problems with the furnace. Even if a rental unit was in poor condition when a tenant moved in, the landlord still has to repair the unit so that it is fit to live in and in compliance with health and building standards required by law. Tenants are required to tell the landlord when their unit needs repairs or other kinds of maintenance. It is important for the tenant to tell the landlord about things that need to be fixed as soon as they are discovered. Landlords need to know what is happening on the property so they can deal with the problems quickly before they get bigger. If the landlord has extra expenses as a result of the delay in finding out about a problem, they can even make a claim against a tenant who knew about a problem in their unit and didn't report it. For example, if your toilet wouldn't stop running and you didn't tell the landlord for a month or two, they could make a claim against you to get back the extra money they had to pay for the water bill. When your unit needs repairs, you should let your landlord know in writing. Make sure that you give the request to the landlord, not just the building's caretaker. Keep a copy of your request so you have a record in case the landlord or caretaker tries to say you didn't notify them. If you are late paying your rent or have missed paying rent, the landlord does not have to make the repairs until the rent is paid. However, the landlord can't withhold repairs to vital services such as water, heat, or electricity. If your landlord does not agree to the repairs or does not do the repairs, you must continue to pay your rent, or your landlord could have grounds to evict you. However, you can go to the Residential Tenancies Branch to ask for help. The Residential Tenancies Branch is a government body that provides information to both tenants and landlords about their rights and obligations. The Residential Tenancies Branch also investigates matters between tenants and landlords. First, you will fill in a form called Tenant's Request for Repairs. This is a simple form that asks for basic information like when you moved in, whether you owe any rent, the details about what has happened so far, and what repairs you are asking for by what date. The amount of time you write down has to be reasonable. You will have to estimate this based on how urgent the repair is, how much work needs to be done, and other relevant factors. After you submit the form, someone from the Residential Tenancies Branch will contact the landlord about the repairs and may come to look at the rental unit. If they agree that repairs are needed, the landlord will be given a reasonable amount of time to do the work. If the repairs aren't done, the branch can make an order saying the landlord has to finish the repairs by a certain date. If the landlord disagrees with the Residential Tenancies Branch order, the landlord has the right to an appeal, where they would ask the Residential Tenancies Commission to review the branch's decision. The Residential Tenancies Commission is the government body that deals with appeals from the Residential Tenancies Branch. If the landlord causes an unreasonable delay in making necessary repairs or does not make them, and you lose the use of the facilities or services in the building, or you have to pay expenses because of the lack of repair, you might be able to get compensation. To do this, you can file a claim for compensation at the Residential Tenancies Branch, which may be heard in front of a hearing officer. You can make a claim for things like rent, damages to personal property, loss of personal property, utility bills, compensation for moving costs, interest, and any other relevant expenses. First, you must submit a form called Tenant Claim Notice of Hearing Form and pay a $50 filing fee. The form clearly explains what you need to include and what you will need to bring to a hearing. You will have to add up your expenses and list them on the form with an exact amount that you are claiming. If you choose to, you can fill in the offer to settle details on the form. You must give the form to the landlord either by handing it to the landlord or sending it to the landlord by registered mail. If the landlord agrees to participate in the mediation process instead of attending a hearing, a mediator can work with you and the landlord to come to a confidential agreement. If the landlord does not agree to mediation, the Residential Tenancies Branch will set a date for a hearing in front of a hearing officer. At the hearing, you should have detailed notes about what happened and when, photos of what needs repair, and any relevant receipts for expenses. For example, if the building's parking garage needed a repair that wasn't made and you had to rent parking in another lot, you should keep a photo of the closed parking garage with the date noted, the receipts from the other parking lot, and records of communication you had with the landlord. At the hearing, you will also need to show that you tried to prevent or reduce the amount of your losses. For example, if the landlord refused to repair a hole in the window where rain came in, you would still have to show that you tried to prevent damage to your belongings by trying to cover the hole or moving your belongings away from the window. If you left something valuable by that window when you could have moved it somewhere else and it got damaged, you would probably not be given compensation for it. You must also show that the landlord knew there was a problem and repairs were needed. For more information, visit the Community Legal Education Association's website at www.communitylegal.mb.ca.